Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. Still late. I'm so good at it. There's probably nobody better on earth at being late than me. I was going to say who's white, but black people aren't late. They're on time. They're just on their time. And that's theirs. That's theirs. And we don't get to take it from them. Anyway, what's up, guys? A little bit later start to the show tonight. And I'm not talking about me being late. I mean the show itself being late. An unexpected thing come up with picking up my son. We didn't think it would be as late as it was, but here we are. No big deal. Not going to dwell on that. A couple quick things, and we're going to get into the show. I'm going to try and get this bad boy moving along tonight after the show. If you don't know, pretty much there's some circumstances where it doesn't happen, but usually after the show, I do a locals exclusive show. And tonight we are doing another locals exclusive call-in show. So I don't want, I don't want to be going into the weeest hours of the morning tonight. So people do have a chance to call in for that. I was on with Azia Land earlier. You may have seen her on Camelot stream. If anybody actually even watches that show. But I was on her show today. It was a ton of fun. Very lighthearted, good show, good chat. And, some people might like what happens over there. She has a pretty interesting show format. And I knew this in the back of my mind, but look, I'll be honest. I had not watched her show before. I haven't watched most people's shows ever until I get on them because, well, I don't watch a lot of stuff. But the premise of the show is it's called Unqualified Experts, and basically grab some advice questions from things like Reddit or whatever, and give our honest takes on them. Although we had such a good conversation going up to it, it really took a while to get into that part of the show, and I thought it was just an absolute blast. So go check it out. Not right now, though. Don't leave. Please don't go. Don't go. No. The numbers, they're full. Anyway, it was a great show. Go check it out later. Actually, it was her. This is for Camelot. It was her highest income stream ever. Camelot. Sorry, Camelot. Okay. With that, we've got some really big topics tonight. Actually, finally, I've been talking about this thing coming for a while. Trump has moved to dismiss his Washington, D.C. election interference case. Stay down like a Brit in a trench. This is one of the numerous election interference, election fraud cases that are out there. He has moved to dismiss it under the concept of presidential immunity. I mentioned this was coming. I predicted this, but so did just about anybody who has a grasp of the Constitution, what presidential immunity is. This is not some crazy thing that nobody could see coming. This is the obvious play that we were waiting for. And I think I have an idea of why we had to wait so long. Just an opinion, not, this is a strategy question because Trump could have brought this really at any time. And there's some interesting factors to this thing. And I'm going to try and grab the document itself, which I think is out there, but I haven't had a moment to actually grab it since I saw that they filed this thing today. I know I can get it in one way or another, but we're going to grab it. We're going to read it. Depending on how long it is, we might skim through some of the arguments instead of doing the whole thing, but we're going to get into it into the meat and balls of this thing, because this is critical. This is an unanswered constitutional question. This will make constitutional law going forward. This is, I mean, you get to see this from time to time, usually in little ways, little constitutional question here, little constitutional question there. However, this motion in this case ultimately gets decided, which will start and then get kicked up eventually to the Supreme Court. And they're basically going to have to take this thing. It's a novel area of law, and it's way too juicy to ignore. How this gets decided will be the anchor for deciding presidential immunity in regards to criminal indictments going forward. And this impacts every election fraud case against Trump only, for sure, but it may have implications to other agents of Trump as well, like his attorneys and stuff like that. That's a little bit more of a complex question. But for now, we're really curious about how this is going to hit Trump, because any future president that is criminally indicted will be raising this claim if it's available. Even if it's not available, they'll be raising the claim and saying that theirs should apply in a different way than this one. But I think this case is prime and ripe for an honest analysis from the Supreme Court. Can they do it is the question in this environment. We'll see. But this is not like a little, oh, we get to tweak an area of Fifth Amendment jurisprudence or Fourth Amendment interpretation. Like, these things happen every single term, narrowing or expanding in very small ways, understandings about freedoms under the amendments, definitions, other existing precedent. This will be a landmark decision on this unheard of question, because no prior president has been indicted before as a sitting president or a former president. And as a reminder, President Bill Clinton was almost indicted for lying under oath, but came to, I believe, a pre-indictment diversion agreement, or basically a pre-indictment plea, to avoid the actual criminal indictment. So we haven't answered this question yet. Big news, big news. Probably the biggest news to come out of any of these Trump cases. And assuming, however they rule, this will likely also apply linearly to the Georgia state election case and any other states' election cases that they may bring up. This will make history. This will have wide-reaching implications, whichever direction it goes. So, the question is, why didn't Trump just file it right away? He could have. And I have a theory about why. I think it's a very specific strategic move, and I'll relay it when we get into that subject in just a few minutes. And you guys can tell me what you think, but we're in a different age. We're in an age of social media, communication, and public influence. And strategy in lawsuits had to change, still has to change, and will continue to change for quite a while to come. Emphasis on while. Next, we will talk about Letitia James, the New York Attorney General, in her post today, saying the art of the steal is what it was called. And it was a disparity, an alleged disparity between Trump's claim of Mar-a-Lago's value being at $872 million versus an approximate value with an asterisk of $25 million for Mar-a-Lago. We're going to talk about this. It's right in the theme of what we were talking about yesterday. And there's just so much to say on this subject, but we're going to approach it first from a very specific hermeneutic. We're going to look at it in the context of ethics violations. This is a prosecutor, the state attorney general, in a state civil, not criminal case against Donald Trump, where he is specifically named. And this state prosecutor has tweeted out something that is at least referential to evidence and a claim with a disparaging remark about a defendant in an ongoing case. This is kind of wild. They are not supposed to do things like this. But does this mean that Letitia James actually violated her ethical obligations in this instance? And I want, with all of my fucking colon, to blast into the atmosphere that she did, but I don't think so. It should be, to be very clear, it should be an ethics violation on her part. But under the letter of the rules and the specific circumstances of this case, as much as it pains me, and I want to be the rah-rah guy who says she should be fucking disciplined, and maybe she still should, but under the rules, I don't think so. I don't think so. And it hurts me to say that because, like, guys, this YouTube game, no joke. Like, I could make a very short video about that, pop it out on YouTube and a couple, and Rumble and promote it a lot on social media and a bunch of stuff. If it hits the right trends, that video could make thousands of dollars. A very, very aggressive headline and a good, like, fire and brimstone approach. Like when you're telling a gay man he's going to burn in hell for the rest of his life. Like, you can do that. It's so tempting to do that on YouTube all the time. But an honest assessment of the situation and a sobering, not a sober one, we don't do that, but a sobering assessment of the situation says, in this case, due to the circumstances, I think she's within the rules, but she shouldn't be. And I fucking hate it because I just want to do the thing that makes me a shitload of free money from YouTube ads. Like, oh God, you just want to do that. You just want to say the easy thing, but this is not the easy thing. So we're going to be honest about it. We're going to talk about why I don't think. Now, I'm just a guy. I'm giving an opinion, right? Giving an opinion. And lawyers often give opinions that are not correct. Either there's some facet of case law we don't know. A judge just decides it should be the other way. In this case, I think that's very unlikely, right? Because of who it is and what's going on. But in my honest read of it, and I'm going to tell you exactly why I don't think so. So I don't want to do that, but we're going to have to. Then I've got some other thoughts and musings, some kind of lighthearted stuff from Twitter that we'll see if we get around to. But these two topics are going to be pretty meaty tonight. And they might take up a good amount of time, which is why we're going to get into them right now after that little preface. So thanks for bearing with me on that. We're going to get going here. By the way, just as this completely unrelated to anything. So my music playlist as I drive around is through Google Music, which usually plays me songs that I know, but then it also will recommend songs that it thinks you will like based on, similar artists or even the same artist, deeper tracks, etc. And it played for me today, The Final Solution by Sabaton. Whew. Sabaton's a cool band, man. But I was like, what? Okay. All right. Let's get into this. Let's get into this. And we'll do this. Frederick Little says, Nick, today is my 31st birthday. Can I get a toast and birthday shout out, please? Of course. Great way to start the stream. Thank you, Frederick. We'll do that. Was Sabaton pro or anti? Look, do you think they could sell albums if they were like, the final solution was right? No, they didn't do that. But it is the thing I like about Sabaton is that they have an overall perspective on various conflicts that you would kind of expect to have to, like, not be canceled immediately. But they're also pretty neutral when the underlying issue to what's going on is not the critical, like, political or historical implication of the act. Like, if they're just like, they have what was that? The Nazis had a fucking ass kicking battleship. It was it ended up getting sunk, but it was a motherfucker. Like the Bismarck, like they have a song about the Bismarck, and it's, like the implications of Germany and the war and World War II are irrelevant to the story of the Bismarck, but the Bismarck was a fucking cool ship, like very, very effective battleship. And I had a book about it as a kid. Like I don't know much about that in general. It's just like read a lot about the Bismarck and when they found it, lying at the bottom of the ocean and all that stuff. But like their song about the Bismarck is just cool, just a good song. But yeah, I really like them because they're relatively neutral on things that happen and people who are involved, so long as the underlying like moral principles aren't at stake. Let's see. We've got oh yeah, so to Frederick Little, happy 31st birthday, brother. A toast to you. 31, man, trekking through those early threes. Dude, it's an adventure. It's an adventure, but one that is ultimately rewarding. Men age like wine, women age like cheese. The older they get, some of them get a little bit sweeter, a little bit stinkier, and some people may like them, but a lot of them just mold. Guys, on the other hand, by and large, get smoother, cooler, a little more expensive, and a little more discerning. Enjoy your aging, brother. Get in the barrel. Cheers. But oh my gosh. We the Rabble says, let's have a toast to Norm Macdonald just because. Yes, Norm Macdonald. And again, one of my favorite jokes is his joke about Germany being scared of it, just kind of in context there. But to Norm, the only dead comedian anybody cares about. Okay. Marries me. I was kidding. Oh my goodness. I'm just going with the internet. All right, here we go. Let me grab this thing. Trump motion to dismiss DC case. The frustrating thing about most of these news stories is they don't want to put the document in the news story. They really don't. So you have to like find the one that has it, but looks like I've got it right here. Perfect. Go the fuck away. We've got it. Go zoom it. This is 52 pages. Now we'll see how many of those are actually useful. But again, we're going to go into this thing right now, and we'll just see where we end up. We've got, oh shit, Smudge Porter Bridges says, Nick, first time super chatting. Thank you. I hope you enjoy your first time. Been here since just before Kick Vic. Thank you for years of edutainment. Also want to shout out my best friend's GoFundMe for her fight against stage 4 colon cancer. How, if any, can I link it? Well, Smudge Porter, if you can get it to one of the mods, or if you can direct message it to me, we can share it. If you can get it one of the mods, maybe they've got a way you can DM them. They can share it, they can tag me and get my attention. Or if, like I said, if you have a way to DM it to me and can tell me, I can grab it and share it. You cannot share things. You're not a mod. You can't share links, and there are too many Asian porn bots. Except on Rumble, you can share links all you want. Same within my locals page. All right. So here we go. And I would be happy to share that out. Thank you, by the way, for super chatting and being such a long time viewer. All right. So we've got table of contents. We're not going to get into the table of authorities and all that shit. We're going to go right here into the introduction, which will give us a summary of the arguments we'll see. We'll read the legal standard and we'll go. We're going to go. I don't know how many of you guys have been around to see me do this, but this used to be kind of how I would do a lot of shows. We would grab a legal document and just go through it word for word. A lot of those weren't as long most of the time, or they're funny or whatever. This is a critical argument. So we're going to spend some time doing at least close to that. All right. And Adriana, of course, welcome. Welcome. Sorry, you're a lesbian now. The President of the United States sits at the heart of our system of government. He is our nation's leader, our head of state, and our head of government. As such, the founders tasked the president and the president alone with the sacred obligation of taking care that the laws be faithfully executed. This is actually the take care clause. This is not a made up thing. This is a duty, responsibility, and right of the president, which gives the president the power to also decide when to enforce the laws less. For example, the president gets the power to take care that the laws are being faithfully executed. If you try and sue the president for not doing the laws enough, you'll likely lose. It'll likely be dismissed under the take care clause. So just so you know, that's a real thing. The president has this authority to do it. So you can't really force him to enforce the law. And we've seen a lot of conflict with this over the borders and stuff like that. Okay. To ensure the president may serve unhesitatingly without fear that his political opponents may one day prosecute him for decisions they dislike, the law provides absolute immunity, quote, for acts within the outer perimeter of the president's official responsibility, citing Nixon v. Fitzgerald. And this is where presidential immunity in the civil context is really kind of laid out. Breaking 234 years of precedent, the incumbent administration has charged President Trump for acts that lie not just within the outer perimeter, but at the heart of his official responsibilities as president. And this is a critical point that we'll get into in the legal argument. The president cannot be immune from unofficial acts while he is president. So if Donald Trump is, I don't know, if he's beating a person with a baseball bat at a little league game, not as president, but just because he's mad, he's not immune from that. But if he's acting in his official responsibilities as president, the argument, at least from the argument for a criminal case or the reality within a civil case, is that he must be immune from suit. If he's acting as the president, doing president stuff, he must be immune. In doing so, the prosecution does not and cannot argue that President Trump's efforts to ensure election integrity and advocate for the same were outside the scope of his duties. Instead, the prosecution falsely claims that President Trump's motives were impure, that he purportedly knew that the widespread reports of fraud and election irregularities were untrue, but sought to address them anyway. Now, I want to hit this point really quickly because they're obviously going to say that Trump definitely 100% believes that the election was stolen from him. And I think that's been rather well demonstrated. Honestly, if we take a real look at how Trump has acted and what he said, he believes the election was stolen. Presidential immunity does not hinge on the president being correct or incorrect, irrelevant. And I would argue that presidential immunity doesn't actually require the pure motive that they're mentioning here. This is an interesting and weird sort of conundrum that we sometimes run into in law, especially when it comes to government. If there is a plausibly reasonable interpretation of the actions of the president that would make them of the pure motive, then he should be given deference to that pure motive. In the same way, we look at it this way with immunity from police officers for civil rights violations when they pull over a black guy for being black, but he also was driving 4 miles over the speed limit. Now, they can even say, I pulled him over because he was black and I didn't trust it, but I also clocked him speeding at 4 miles over the limit. And technically, they're allowed to do that. Their actual motive is not pure and would not be sustainable under the Constitution. However, they have a plausible alternative that is justifiable, and that is a violation of a statute. So since they have the statutory violation, it shields their impure motives. In a similar way, although not quite in the same vein, if President Trump and his actions could be plausibly inferred to be his concern over the election and election integrity, that should still qualify as presidential immunity. I don't think they're going to argue that here. I'm not in court. I'm not speaking on behalf of Trump or his team. I can safely make that argument without any of the sort of political ramifications that might be there. But this idea that we get to mind read a president or anybody else and then make them affirmatively disprove your mind reading conclusion puts a burden. It shifts the burden onto the defendant to first prove an element of a crime that they should not be charged with, or a civil infraction that they shouldn't be charged with. And that is not how this works. Trump's state of mind is a very important fact question if suit can be brought. But Trump doesn't have to prove that state of mind. The prosecutor does. Trump's assumed and presumed, required by the Constitution, state of mind is that he's actually concerned about election interference and election integrity, because he is innocent until proven guilty. I think everybody in the fucking media forgets that that's a thing and that it applies to Trump, even though they don't like him. But that's true. And he shouldn't have to prove that out in an immunity question, because the immunity question is immunity from suit, not immunity from suit once you prove your motives were good enough, because a judge could just rule that the motives aren't good enough. Right? And then you're then appealing the judge's opinion of your state of mind in a case that hasn't been tried. It's a mess. Just conceptually going through it, it's an impossible standard to meet. So though I don't think they will make that argument, watch, they're going to do it, but though I don't think they will, I will say that even if Trump has impure motives, if this still could be an official act of the president and he is acting within his capacity, then I fully think that it should be immune, even if his motives are impure, because that's how criminal defense actually works. And that might be very uncomfortable for people going, well, I can't believe you would say he should be immune from suit when he might be guilty. It's like, well, sorry, criminal defense is standard, not selective. All right, so we're going to keep going here. Instead, yeah, they claim his motives were impure. But as the Constitution, the Supreme Court, and hundreds of years of history and tradition all make clear, the president's motives are not for the prosecution of this court to decide. Oh, shit. No, it's right there. Rather, whereas here, the president's actions are within the ambit of his office, he is absolutely immune from prosecution. They did do that. They said it a little bit more concisely, but good. Spalding versus Vilas. The allegation of malicious or corrupt motives does not affect a public official's immunity, and the motives that impelled the official to do that of which the plaintiff complains is wholly immaterial. Therefore, the court should dismiss the indictment with prejudice, citing Midland Asphalt Corp versus United States. Dismissal of the indictment is a proper sanction when a defendant has been granted immunity from prosecution. Now, this is really important. Again, this indictment has to be, based on this motion, either dismissed or not dismissed. If it is not dismissed, it should be immediately appealable, and it should further grant a full stay on this case and any other similarly situated case, although they'll probably have to file paperwork in those cases, because the answering of the immunity question, as we saw actually in my appeal, right, on we'll compare me to the president. In my ongoing defamation case, we have appealed based on the fact that under the statute and the law that we believe should be applied, I should be granted immunity from suit, not immunity from judgment, not immunity from anything other than the entirety of the suit, which makes it critical to decide this question at the onset prior to the suit commencing. Same thing here. Trump is to be granted immunity from all of it, including discovery, depositions, the burdens being placed on him, any temporary injunctions during the pendency of the action. All of those things are infringements of his rights that he should not have to endure should the suit be terminated at this early juncture. And so to find otherwise means an immediate appeal will follow, and it should be dealt with. And that immediate appeal will likely follow with an appeal to the Supreme Court to ultimately resolve the issue. So this is, again, a very important part of this, that this is about full immunity from the suit, not immunity from liability, not immunity from anything other than all of it. All right, couple super chats. Maki Sekersitina says, can you toast my permanently suspended Twitter X account? I had less than 100 followers and mostly talked about Catholic things. Immediate rejection on appeal and gave no specific reason. I was banned. To your long dead Twitter account, or recently dead, but soon to be long dead Twitter account, may it rest in peace. May your banning bring you actual joy, comfort, relaxation, and ultimately contentment. Amen. Nomine et Patri et Filii et Spiritus Sancti. Millionaire Bear says, can you play this anti-Klaus Schwab song? Good luck on stand-up with Chrissy. Millionaire Bear, yes. I'm going to keep this super chat open until we get over to Rumble later, though. And we'll do it then. Next, we are back in the document. All right, so now we're into the legal standard. In ruling on a motion to dismiss for failure to state offense, a district court is typically limited to reviewing the face of the indictment and, more specifically, the language used to charge the crimes. When considering a motion to dismiss, the court must review the face of the indictment, and the indictment must be viewed as a whole, and the allegations must be accepted as true at this stage of the proceedings. So they're going to say, for the purpose of the argument, everything stated in the indictment is true, and still this must be dismissed under presidential immunity, because even if Trump did everything they said in there, he's not able to be charged under it. Neil Conway, he ignored me because I'm an Indian. I knew it. That's true. That's true. Allegations in the indictment. President Trump, the incumbent administration's leading opponent in the upcoming presidential election, which is kind of important for a lot of things, but not actually for this motion to dismiss, emphatically denies the truth of any allegations in the indictment. Rather, this memorandum sets forth the facts alleged in the indictment so that their legal sufficiency may be assessed for a motion to dismiss. Moreover, the Supreme Court has repeatedly stressed the importance of resolving immunity questions at the earliest possible stage in litigation. So he is laying out, obviously, that he denies everything alleged against him, but they're going to go through it. And again, they all will be taken as true for the purpose of deciding the motion. If that's true, then why is Trump playing their game? What do you mean playing their game? But I don't know what you mean by that. If I see your response, maybe I'll answer. Here we go. Accordingly, this motion addresses only the question of presidential immunity. Other fatal deficiencies in the indictment will be addressed in future motions and proceedings. And again, I mentioned this a long time ago when I kind of previewed that this should be coming. There are also First Amendment freedom of speech issues here in this indictment. How can it be illegal to assert that an election was stolen? I mean, that's a really good question, right? How can it be illegal to assert that a public endeavor of the highest public, interest in the United States, the election of a president, asserting that it was stolen or fraudulent? How can that not be the most critically protectable speech that we have? Lone Wolf says he has presidential immunity, therefore he is immune. Well, I don't know what you mean. I don't know what you mean by playing their game, but presidential immunity has never been decided for a criminal indictment because it's never had to be decided. It's never been done. So he has to establish that he has the presidential immunity, which means he has to get a judge or ultimately the Supreme Court to decide that it applies to criminal case and therefore applies to, and then subsequently applies to this criminal case. I believe it should. They're going to assert it, but yeah, I mean, they have to actually get a court ruling on it. Okay. The indictment alleges that President Trump took a series of actions that form the basis of its charges. These acts fall into 5 basic categories. The indictment alleges that President Trump, while he was still president, 1, made public statements about the administration of the federal election and posted tweets about the administration of the federal election. 2, communicated with senior DOJ officials about investigating election fraud and about choosing leadership of the DOJ. 3, communicated with state officials about the administration of the federal election and their exercise of official duties with respect to it. This is talking to about Georgia and maybe some other states. 4, communicated with the vice president in his legislative capacity as president of the Senate and with other members of Congress about the exercise of their official duties regarding the election certification. Yes. And 5, authorized or directed others to organize contingent slates of electors in furtherance of his attempts to convince the vice president to exercise his official authority in a manner advocated for by President Trump. Now, they've written this semi-favorably towards Trump. And sorry, I didn't have that enlarged. We'll do that in just a moment. They've written this obviously favorably towards Trump, but yeah, I mean, so he tweeted about the election, said it was stolen. He communicated with senior DOJ officials about investigating it. They gathered data from all over the place. They challenged states. They asked them to do stuff. He had Rudy Giuliani and Jenna Ellis, actually trying to take part in some of the lawsuits about it. Communicated with state officials about the administration. Called Georgia, right? He called them up, said, I don't think that this actually was done right. I think that there's some problems with it. Let's talk about it. We need to find these votes that we believe we have. Communicated with the vice president. Yeah, he talks to Mike Pence about not certifying the results that are submitted of these slates of electors, about sending them back to the states for a review, for an audit, for a redo, if you will. And Mike Pence didn't do it, but Trump could certainly ask him to. And then finally, authorized or directed others to organize contingent slates of electors. Yeah. Look, and here's the reality. The slates of electors have a constitutional deadline to reach the vice president. Sending alternative slates to the vice president, should a state decide to withdraw the sent electors based on a challenge to the data, would get that alternate slate of electors in front of the vice president in time to meet the constitutional requirement. Now, people are saying, the prosecutors saying, various critics online will say that Trump organized those slates of electors in an attempt to dupe America into reelecting him or whatever. As if, and again, you always have to understand that when they explain the logic behind their reasoning, it's always that Mike Pence must be retarded, right? It's always that Mike Pence must just get this alternative slate of electors and be like, yeah, actually, California did go for Trump. I'm going to, like, that he must be a clueless moron in the inaction of his duties and that no one would check anything out about this. We can make jokes about Mike Pence and all of that, but the reality is you have to assume that the person doing what Trump is asking them to do has no will, no consciousness, no knowledge of anything to accept their behavior or to accept his behavior as somehow controlling, manipulative, or deceptive. I don't think Mike Pence getting Georgia's slate of electors and then getting another slate of electors in Georgia that are all Republican goes, you know what? I don't know which one is real. Like, I don't think he does that. Maybe I'm wrong. I'm not sure. But I have a hard time believing that he's like, hey, God, you just can't decide between the two. Like, which one's the correct one? Like, he's going to reasonably determine which is the right one. I don't think deception's going to get him there. But we go on. So now we're going to get into each of these claims. Public statements about tweets about the federal election certification. First, the indictment alleges that President Trump, while he was still president, made public statements about the administration of the 2020 election. And then they cite all the different places. Here's a footnote, though. In certain cases, the indictment does not specify whether President Trump had direct involvement in many of these actions or even knew they were occurring. But even assuming that he did, the acts alleged are still of a public character. So they're saying the indictment's not entirely clear on which ones might not pertain to Trump. So here we go. Public statements about disputing all of these different election concepts. I'm not going to read through them all. Closely related to the allegation of public statements, the indictment alleges that President Trump posted a series of tweets about the administration of the federal election and its certification. Tweets addressing the evidence of fraud in Georgia, tweets criticizing Pennsylvania's legislators' claims about electors, tweet addressing election fraud in Wisconsin, tweets urging Americans to protest fraud in the election. So tons of tweets about this stuff. Now, so that's what's alleged. And these are the paragraphs of the indictment where those things are alleged. So now we have communications with the U.S. Department of Justice about investigating election crimes and possibly appointing a new attorney general. The indictment alleges that President Trump attempted to, quote, use the power and authority of the Justice Department to conduct election crime investigations. And this is the ultimate problem with this. Like, this is problem after problem after problem with the underlying indictment. The indictment alleges that the President of the United States attempted to use the power of the Department of Justice, of which he is the boss, to conduct election crime investigations. Well, yeah. Like, that seems like something the president could do within his power to do so. But I don't know. Nikki941 says, thank you for covering the Wood County case yesterday. Ohio's great for logistics, thanks to our geographic position, but then also one of the worst for drug and human trafficking, hence the harsh penalties. Yep. Absolutely. Okay, so here we go. Back to election crime investigations and to send a letter to the targeted states from the Justice Department that claimed that the Justice Department had identified significant concerns that may have impacted the election outcome. Sounds like a duty of the president. It really does. The indictment alleges a series of meetings and communications between President Trump and others, including senior officials in the U.S. Department of Justice, relating to the investigation of federal election fraud and possibly appointing a new acting attorney general of the U.S., which, as the indictment states, President Trump ultimately did not do. They alleged a meeting with the incoming acting attorney general and acting deputy attorney general to discuss allegations of election fraud, phone call with acting attorney general and acting deputy attorney general to urge them to investigate election fraud. So they've got meetings. They're asking the attorney general and the deputy attorney general to investigate the fraud that they believe they have found. Again, it kind of seems like the president asking the Department of Justice to investigate fraud, which would constitute federal crimes, may be within the purview of the president's official duties. So again, I'm not going to read all of the individual allegations in each of these paragraphs. We'll get to the main arguments about it all in a minute. Communications with state officials about federal election and the exercise of their official duties with respect to the election. Diamond alleges a series of communications, some by Trump and some by other unnamed individuals with state officials about the administration of the federal election, the exercise of their official duties with respect to the federal election. Communications with Speaker of Arizona House of Representatives, members of the Georgia Senate, et cetera, et cetera, et cetera. So yeah, they called other politicians, probably political allies, and said, hey, we see some fuckery afoot. We need to fix it. We need this. We would like you to consider withdrawing your certification of the election results. Again, makes sense. Communications with the vice president, members of Congress about the exercise of their official duties in the election certification proceedings. Diamond charges that President Trump attempted to enlist the vice president to use his ceremonial role at the January 6th certification proceeding to alter the election results. And by the way, ceremonial role is not a constitutional thing. Now, I would even argue, usually and basically, that maybe should be considered a ceremonial role. I don't know that the vice president gets to determine this shit. But the reason I say I don't know is because I don't know. It's not decided. It's not written down. And the Supreme Court hasn't ruled on whether or not the vice president can actually do what he asked Mike Pence to do. But just as a brief aside on that, the Supreme Court may never rule on that question because it is an expressly granted role or power to the vice president. It is not necessarily for the Supreme Court to limit the vice president's authority to enact that role in the way he sees fit. It very likely is plenary authority and a political question that would be better answered by impeachment if Congress does not like the way in which the vice president handles the situation. And yet again, we're stuck with this critical question. Can they do any of this? Anybody, by the way, Congress, Mike Pence, what do these things mean? We don't know when it's not expressly written down and not answered by the Supreme Court. But how would you answer this? If Mike Pence had gotten up and says, I actually am going to send this slate of electors back to the state of Georgia and ask them to double check their results and to resend their slate of electors. Now, if they just get it and say, we're good, fam, and send it right back to him, what does he do? I don't know. If Congress doesn't like that, they can impeach the vice president and remove him. But it's hard to think that this might happen. Well, yeah. These questions aren't easy. They're often difficult and they make for very messy government. But sometimes you need the government to slow to a fucking crawl and make it messy to answer something difficult and uncommon. Difficult and uncommon situations like the potential fraud of a presidential election during a pandemic with very untested and novel processes for submitting absentee ballots in numbers never seen before might need a solution that's not so cookie cutter. They might have questions that aren't so quick. And that's why the founders may not have said ceremonial role, because even though it may largely be ceremonial, I mean, because most elections, you're going to get there, the electors are going to be selected, you're going to go, okay, cool, you read the cards, and then you're done. But the one time that it's not that is probably not easy. So that's why these things don't say ceremonial role, even if it might normally be one, because there may be a day where it isn't. And for anyone who says, well, the founders couldn't have thought, why not? Why couldn't the founders, coming out of a system of abject corruption, which is a monarchy, why could they not consider the possibility that someone assuming the temporary role of the monarch might cheat, and that someone at multiple layers of government might be the only guy who can put a pause on the cheating? That is not a strange thing to consider. It's actually strange to consider people coming of a tyrannical and corrupt system to not consider the possibility of cheating and lying. But alas, here we are pretending again that the founders are retarded. All right, back to this. By attempting to convince Vice President to rely on contingent slates of electors submitted by the president's alleged allies. So again, we're not going to read all these, but you get the idea. He's talking about, decertifying, or when he's talking to House of Representatives and Senate members, they have the opportunity to object to slates of electors based on various, pretty much any reason they want to bring. So asks people to do, I think there's fraud. Please stop this. Interject and stop this. Here we go. Organizing slates of electors as part of an attempt to convince legislators not to certify the election against defendant. Closely related to these communications with the vice president, members of Congress, the indictment alleges the other individuals organized slates of contingent electors from several states to provide a justification for the vice president to exercise his official duties in the manner favored by President Trump. Yes, because of course, if you believe there's fraud, then you would create the system by which the fraudulent thing can go away and the non-fraudulent thing can take its place. Only makes sense. The Squid says the president is the head of the enforcement arm of the United States government. Of course, it's his duty to ensure that potential crimes get investigated. Why else do federal marshals, the FBI, and the DOJ exist? Correct. So, argument, the president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibility. Now, they're saying outer perimeter again, citing Nixon versus Fitzgerald. But their argument is not that these are outer perimeter actions, they're inner perimeter actions. In view of the special nature of the president's constitutional office and functions, a current or former president has, quote, absolute immunity from they put in civil damages liability for acts within the outer perimeter of his official responsibility. And again, they put in civil because that's the case. Criminal case has never been brought because it's never needed to. No court has addressed whether such presidential immunity includes immunity from criminal prosecution for the president's official act. The question remains a serious and unsettled question of law. Seeing the Fitzgerald case, holding in light of the special solicitude due to claims alleging a threatened breach of essential presidential prerogatives under the separation of powers issues of presidential immunity were serious and unsettled. In addressing this question, the court should consider the Constitution's text, structure, the original meaning, historical practice, the court's precedents, and immunity doctrines and considerations of public policy. So the Nixon versus Fitzgerald case considered that this might need to be applied in the criminal context, but since they didn't actually have a criminal factual case to work with, they couldn't do it. The doctrine of the separation of powers and the president's unique role in our constitutional structure require immunity from prosecution. And this is something I've talked about a lot lately because everybody just thinks that we know what the president is and does as a matter of course because of how presidents have been and done for a while. But up until FDR, all presidents would only be elected for 2 terms because that's what they did. Not because they were required to. Then FDR got his 4th election. They're like, well, maybe we should stop this. We don't want this to happen too often. So they limit it to 2 terms. But that required a constitutional amendment because it wasn't in there. There's a bunch of stuff presidents don't do and could. And they might win on them. They might win on all of them because the president is king for 4 years, maybe 8. And kings have a lot of power. The only power that the president doesn't have as kings is what's given to Congress in Article 1, really around Section 8 and 9. Everything else is just the power of the executive. So the president occupies a unique position in the constitutional scheme. Article 2, Section 1 of the Constitution provides that oh my God, it's almost like I've taught this over and over. The executive power shall be vested in a president of the United States. This grant of authority establishes the president as the chief constitutional officer of the executive branch entrusted with supervisory and policy responsibilities of utmost discretion and sensitivity. Due to this unique status in our constitutional structure of separated powers, which distinguishes him from other executive officials. This is important, by the way, because this distinguishment from other executive officials has to do with that 14th Amendment thing as well. We talked about that the other day, where Trump is probably, or I don't know, probably should not be, in my opinion, and may not be in reality, subject to the disqualification clause of the 14th Amendment. Now, Trump hasn't been found guilty of an insurrection or participating in one at all, but should he be in some way, I guess, found guilty of that, or found to have done so by some finding from some judge or something like that, would he be disqualified? My argument is that you can't actually disqualify anyone from holding the office of the president under the 14th Amendment because it doesn't say it. it says other officials or other officers of the United States, but he is actually distinguished from other executive officials because the president is special. The Supreme Court held in Fitzgerald that the president is and must be absolutely immune from damages liability predicated on his official acts. We consider this immunity a functionally mandated incident of the president's unique office, rooted in the constitutional tradition of the separation of powers and supported by our history. The policies and principles mandating immunity may be considered implicit in the nature of the president's office in a system structured to achieve effective government under a constitutionally mandated separation of powers. Long-winded old bat way of saying the court isn't granted immunity in Article 3 over the president in the Constitution. Congress is granted authority to impeach. That's about it. The court does not have the ability to go after an inherent power of the president. In reaching this conclusion, the Supreme Court held that subjecting a president to personal liability for his official actions would improperly divert the president's energies and raise unique risks to the effective functioning of government, especially given the singular importance of the president's duties. Chief among these risks is a chilling effect personal liability would have on the president's decision-making, particularly in matters likely to arouse the most intense feelings. It is precisely such cases that there exists the greatest public interest in providing an official the maximum ability to deal fearlessly and impartially with the duties of his office. So they're saying the president needs to be able to act without worrying about a lawsuit that would come Could you imagine if lawsuits were allowed against, like civil lawsuits about President Trump's actions were allowed against President Trump? How many, not being sued as president, but being sued as Donald Trump, how many lawsuits would there have been against Donald Trump? I don't know, 1 billion a day, pretty much. 1 billion, unlimited, an incalculable, unfathomable amount. Personally liable. So even if he only had to spend $1 to dismiss all of them, it would have been unsustainable. The concern is compelling, where the office holder, must make the most sensitive and far-reaching decisions entrusted to any official under our constitutional system. Nor can the sheer prominence of the president's office be ignored. In view of the visibility of his office and the effect of his actions on countless people, the president would be an easily identifiable target for prosecution in countless federal, state, and local jurisdictions across the country. Cognizance of this personal vulnerability frequently could distract the president from his public duties to the detriment of not only the president and his office, but also the nation that the presidency was designed to serve. So again, a scheming state prosecutor, right, might be able to bring charges against a president because they're so publicly visible and public in their acts. Now, if that prosecutor, even if they're wrong, wanted to twist those acts into something unlawful, they could. So the president would be second guessing and marking every fucking word he said. Every word would have to be so cautiously considered as to make all speeches useless. It would just be written by lawyers. Although Fitzgerald concerned civil liability, the exact same, if not more elevated concerns applied to potential criminal prosecutions, mandating the same absolute immunity. Vertical and horizontal separation of powers simply cannot permit local, state, or subsequent federal officials to constrain the president's exercise of executive judgment through threats of criminal prosecution. To hold otherwise would be to allow the president's political opponents to usurp his or her constitutional role, fundamentally impairing our system of government. For this very reason, Fitzgerald recognized that presidential immunity is not just a creature of common law, but also rooted in the separation of powers under the Constitution. I keep forgetting to make this larger. So here we've got a footnote. To be sure, Fitzgerald did not decide whether presidential immunity extends to criminal prosecution. It acknowledged that there is a lesser public interest in actions for civil damages than in criminal prosecutions. But the fact that the doctrine of presidential immunity is rooted in the separation of powers dictates that immunity must extend to criminal prosecution as well as civil liability. Yes, great argument. While the public interest in criminal prosecutions may be important, it is not important enough to justify abrogating the separation of powers, the most fundamental structural feature of our constitutional system. Further, exposure to criminal prosecution poses a far greater threat than the prospect of civil lawsuits to the president's maximum ability to deal fearlessly and impartially with the duties of his office, and thus it raises even greater risk the effective functioning of government, citing again to Fitzgerald. Fitzgerald's reasoning, therefore, entails that presidential immunity include immunity from both civil suit and criminal prosecution. 1000% agree with this argument. It is the proper way to look at it. Just because Fitzgerald did not deal with immunity from criminal suit does not mean that it did not contemplate it. It just wasn't the question they were asked to answer. But now we can. With that, though, we are actually going to move the remainder of the show over to Rumble in just a moment. We're going to go through the YouTube super chats, catch up on those, and then we will be moving to Rumble to finish this discussion. Believe it or not, we're already an hour in. That's how we're going to have to deal with this one. Lone Wolf 36S says bread. Kate of the Swiss says, looks like super thanks are working now. I didn't actually do anything, so I don't know what happened. USSJ4 Broly says, why don't scientists trust atoms? Because they make up everything. Sounds like these people. Best wishes to you, Lady R, and the kids' brothers. Stay gay. Well, of course. Also says, when is Lady R joining us again on a show? No idea. Whenever she wants to. Neil Conway says, for your 25-hour stream and manhood. Thank you, Neil Conway. He also says, I understand that much of law is about precedent. If there is no precedent, does this go to the Supremes? Yes. And even if there is, it may go to the Supreme Court. But in this case, there's no precedent. I mean, certainly a lower court could issue a ruling on a novel issue. And in theory, it may not be appealed. But in this case, it will obviously be appealed up to the top. And finally, Brian says, they made the role ceremonial by passing law after the fact. At the time, he had the same power Nixon exercised. With that, guys, pop on over to Rumble with us. It's a beautiful place, wonderful place, terrific, really. It's a beautiful place. You can join us. The show link to Rumble is in the description on YouTube. It's also in the pinned chat on YouTube by C. Goody, the Chief Gay. You can pop over to Rumble and watch the rest of the show. If not, we will see you tomorrow night for another show. Donald Gooch says political question doctrine means SCOTUS must address this or leave presidents subject to every local prosecutor in the country. Well, the political question doctrine typically means that the answer to the proposed question is political and the court should not intervene. That's what they tend to mean. So with that, we are going to pop over to Rumble. I will see you there in just a moment, and we are going to kick right back into it and get through this document as fast as possible. See you there, guys. Peace. Peace.